Let us look at topic 6, legal issues for entrepreneur. At the end of this topic, students will be able to stress the need for a lawyer, explain legal issues in setting up the organization, understand product safety and liability, discuss the importance of insurance, and appreciate the importance of contracts. An external environment comprises of many factors, including the political or the legal factor. All business operations should fall within the legal framework to gain protection from government and support from society. Ignorance of law is no excuse, so good awareness of the laws of the country is necessary for all entrepreneurs. Whenever in doubt or in trouble, legal expertise should be sought by entrepreneurs to tide over a situation. Small enterprises may require legal opinions less frequently than large organizations. Incorporating a legal department within an organization has also been felt as mandatory. Prevention is better than cure. It is preferable to avoid legal tangles like infringements and product liability than fighting it out as litigations. Legal issues can create bad reputations and loss of investor confidence. Hence, just as how individuals are expected to be law-abiding citizens, organizations are also expected to fall in line with the law of the land. Is there a need for a lawyer? All businesses are regulated by law. The entrepreneur needs to be aware of any regulation that may affect his business venture. At different stages, legal advice is required. Lawyers have special expertise, and by seeking the right advice, much time and money is saved. Points to be noted in selecting a lawyer. Lawyer is a professional who is an expert in his field, and he should be appointed for one-time fee or on a retainer basis. Choosing a lawyer is like selecting a good employee. He should be someone who can be related personally. And for prompt legal advice, right decisions, dealing with regulatory bodies, facing lawsuits, and taking legal actions wherever necessary, a lawyer's expert advice is definitely required. So there is a need for a lawyer. What are the legal issues in setting up the organization? A very good understanding of the legal issues is necessary before starting a new venture. Some issues could be related to the following. Patents. Patent is a contract between the government and the inventor which grants holder protection from others making, using or selling similar ideas. At the end of a specific period of time, the government publishes the invention and it becomes part of the public domain. The disclosure will stimulate ideas and perhaps even the development of an even better product that could replace the original. Utility patents. They have a term of 17 years beginning on the date of the Patent and Trademark Office issues it. It is everything about the usage of a product or a service. Design patents. It reflects the appearance of an object and granted protection for a period of only 14 years. That's because it is easy to copy and hence considered actually useless to obtain patent. Plant patents. These are again issued for 17 years on new varieties of plants. It represents a limited area of interest. Plants here we mean plant and machinery. The disclosure document. It is a statement in the US Patent and Trademark Office by the inventor disclosing intent to patent idea. This document can be used if two inventors are filing for patents on similar inventions. In that instance, the entrepreneur who can show that he was the first one to conceive of the invention will be given the rights. The disclosure document is not a patent application but an intent to obtain patent. The patent application should contain the nature, background, advantages of the invention and how different from others. Description like engineering specifications, drawings, materials, components, etc. and claims to be exact by the description to seek protection against infringement. Filing fee ranges from $1,500 to $2,000, and there are 3 maintenance fees during the life of the patent, and above all, an attorney fee to the patent attorney has to be paid. Trademarks. It may be a word, symbol, design, or some combination of such, or it could be a slogan or even a particular sound that identifies the source of sponsorship of certain goods or services. The initial registration is for 20 years with 20-year renewal period, and it allows the right to use in interstate and foreign commerce. Moving on to the registration. Trademarks, there are actually 4 requirements: completion of the written form, drawing of the mark, 5 specimens showing actual use of the mark and the fee payment. Each trademark will have to be applied separately. Once accepted, the trademark is published in the Trademark Official Gazette to allow any party to oppose within 30 days. If no opposition, registration is issued, but actually the whole process takes 13 months from the initial filing. Copyrights. It is a right given to prevent others from printing, copying, or publishing any original works of authorship. And in 1980, the Computer Software Copyright Act was also added to the Federal Code of Copyright Laws. Authors and publishers of software are protected similarly to creators of artistic works. An application form, 2 copies of the work, and appropriate fee will register the given copyrights. The protection is for the life of the author plus 50 years. If through publishers, 70 years from the date of publication. Copyrights are usually given to books, songs, blueprints, scripts, sculptures, music, articles, models, data, poems, maps, or music. So it is definitely an intellectual work. Trade secrets. It is a protection against others revealing or disclosing information which could be damaging to business. It is an idea or a process which is confidential. It will have a life as long as the idea or process remains a secret. Employees are made to sign confidential information agreement that will protect against disclosure, also known as non-disclosure agreement. Unfortunately, protection against the leaking of trade secret is difficult to enforce. Licensing. It is a contractual agreement giving rights to others to use intellectual property in return for a fee called royalty. A royalty is paid in return for permission to copy these intellectual works. It is an excellent option for the entrepreneur to increase revenues without the risk and costly startup investment. The next legal issue that should be borne in mind is related to product safety and liability. It is a responsibility of a company to meet all legal specifications regarding a new product covered by the Consumer Product Act. Product liability problems are complex and continue to be an important consideration for entrepreneurs. Normally, the claims can fall in any one of the following categories: negligence, strict liability, warranty, or misrepresentation. Let us identify the importance of insurance. In order to face lawsuits, it is preferably to take insurance cover, especially if the business is providing services like daycare centers, amusement parks, shopping centers. Workers' compensation is another factor to take insurance cover. Importance of contracts. A contract is a legally binding agreement between 2 parties, and an entrepreneur is starting a new venture will be involved in a number of negotiations and contracts with vendors, landlords, and clients. Courts, though accept oral contracts, insist on written contracts if the value exceeds $500. Written contracts are legal documents which have binding impact on the parties of the contract. When contractual obligations are not fulfilled, it will amount to breach and legal actions can be considered on the breaching party. Contracts also act as evidence or proof of certain duties to be performed. A typical example of a sales contract is that the seller assures the buyer of the quality of the product as claimed in the agreement. There are many famous cases related to product liability and infringement, which are actually learning lessons to entrepreneurs to avoid in future. One such famous case is related to McDonald's coffee. It's about a 79-year-old woman who was burnt. She purchased coffee at McDonald's and there was a severe third-degree burn on her groin, thighs and other parts of her legs, and she required multiple surgical skin grafts and a 7-day hospital stay, and her medical bills were almost $200,000. She had never filed a lawsuit before this, and in fact she didn't want to file this lawsuit. But McDonald's refused to help her pay any of her medical bills. She was asking for just $20,000 to pay some of her bills. McDonald's had over 700 coffee burn claims filed against it before this claim, and was well aware that its coffee was burning people all over the country, and it had already paid over $500,000 due to prior burn injuries. McDonald's intentionally heated the coffee at 190 degrees Fahrenheit, despite the fact that it knew other restaurants only heated the coffee to a safer temperature of 160 degrees Fahrenheit. McDonald's coffee was so scalding hot, it was capable of burning off your skin and causing muscle and bone damage in just 2 seconds. McDonald's tactic in the case was to blame the lady for her injuries, claiming that she didn't take her proper precaution when the coffee spilled. It also argued that due to the age of the lady, it may have caused her injuries to have been worse than they might have been in a younger individual, since older people's skin is thinner. And in this particular case, the jurors rendered a punitive damage award of $2.7 million against McDonald's. And when McDonald's appealed, the judge lowered the award amount to $480,000 after paying her attorney fee, cost and her medical bills. Though the lady was left with very less, she did win the case. So the story that we try to understand from this whole case is that the lady who spilled coffee on herself became a millionaire. So these things to be avoided, at least for the sake of bad reputation and financial interests. So that will be the end of our topic 6, and we should be moving on to topic 7, the business plan. Thank you.